Started. I welcome members to the 23rd meeting in 2013 of the Delegated Powers and Law Reform Committee. I ask members to turn off any mobile phones and I advise that we have apologies from Richard Baker. I'm also very happy under agenda item 1 to welcome Margaret McCulloch to her new appointment to this committee and to Mary Fee, who's the substitute to this committee in place of Richard Baker. Can I ask you good ladies, please, in accordance with section 3 of the Code of Conduct, to declare any relevant interests? Start with vote.
Can I refer to my declaration of interest, which is on the Scottish Parliament website?
Thank you.
Can I also refer to my declaration of interest on the Scottish Parliament website?
Just to agenda item 2, which is a decision on taking business in private. It's proposed that the committee takes item 8 in private. This is consideration of the evidence we are about to take on the Marriage and Civil Partnership Scotland Bill. Do we agree to take that item in private, please? Thank you very much. Which takes us to agenda item 3, which is the aforementioned Marriage and Civil Partnership Scotland Bill. This is an opportunity for members to ask questions of the Scottish Government officials on that bill. And I welcome Simon Stockwell from the Scottish Government, who's the team leader, Julia McCombie, Policy Officer, both from the Family and Property Law teams, and Francesca Morton, Solicitor from the Scottish Government Legal Directorate. Thank you very much for coming to answer our questions. And we proceed, I think, straight to questions. And the first is from Mary Fee.
Thank you, Convener. Good morning. Can I just ask quite a brief question about sections 8 and section 9 of the legislation, and it's around the change of qualifying civil partnership into marriage, and specifically in section 8 it's around paragraph G, where it talks about the effect of a qualifying civil partnership changing into a marriage in accordance with the provision. And then if you move on to paragraph 9 is titled Effect of Marriage Between Civil Partners in a Qualifying Civil Partnership. And I just wondered if you could explain the difference between the word effect being used in paragraph 8 and in paragraph 9. And if paragraph 8 does what paragraph 9 says, or vice versa, why are they both included?
Thank you. In essence, the policy intention is indeed that there will be no difference in effect. So if you change your civil partnership to a marriage under the administrative route established under section 8, the intention is that the effect will be exactly the same as if you had a marriage ceremony under section 9. So our intention would be that any regulations made under 8.2g of the bill would really be mirroring what the provisions contained in section 9 of the bill say. So the policy intention is there will be no difference. It won't matter whether you marry through an administrative route or whether you marry through having a ceremony. The effect, once you're in the marriage, will be exactly the same.
That's very helpful. Thank you for that. That's fine. Yeah.
Very much. Mike.
Thank you, Convener, and good morning. The Delegated Powers Memorandum offers some examples of the sort of consequential changes which may be required to other legislation to accommodate the change in status or to ensure obligations remain the same notwithstanding the change. Can you provide some more clarity on how you envisage this power being used?
Could I perhaps ask which paragraph of the Delegated Powers Memorandum you're particularly referring to there?
Well, there are a number of examples I understand that are given, and it's just a general sense in which you see consequential changes being required.
I mean, in very broad terms, the rights and responsibilities of civil partners and the rights and responsibilities of married couples are very similar in practice. So much of the debate around this bill is in relation to being able to say that you are married rather than being in a civil partnership. So the rights and responsibilities are generally the same. One example where they are different is, for example, in relation to pensions. There can be greater pension rights for married couples when compared with civil partners. And our intention is that same-sex married couples will be treated in the same way as civil partners in relation to pensions. So we may need to make provision in due course so that that policy is achieved, and so that civil partners and same-sex married couples are treated in the same way for pension purposes. And that might indeed need some provision in the bill in respect of contrary provision, because normally we'd be saying that married couples will be treated the same whether they're in a same-sex marriage or an opposite-sex marriage, but there would be some differences such as pensions.
And are you able to point to legislation that is within the province of this Scottish Parliament with regard to pensions, for instance?
On pensions, most provisions in respect to pensions are a reserved matter for Westminster, but the Scottish ministers have got some executive devolution in relation to certain pension schemes in relation to police, fire, local government, teachers, and another one, I've forgotten which one that is, I'm afraid. And there's also some very small pension schemes, Scottish Enterprise and Highlands and Islands Enterprise, where the Scottish Public Pensions Agency has a role in administering those. So we might need to make some changes to those legislation to ensure that same-sex married couples are treated in the same way as civil partners.
Thank you. And going on now, there appears to be no limitation in the power at section 8.2g. Can you explain why that power has been drawn so widely?
It's drawn widely simply to ensure that we can do everything that we need to. Clearly, we need to reflect, as I mentioned, the provisions in section 9. I mean, one example, of course, is that in Scotland, when a couple divorce, the financial provision on divorce is largely based on the matrimonial property they acquired during the marriage. Now, if the couple should divorce after they've changed their civil partnership to a marriage, we'd also want to make certain any property they acquired during the preceding civil partnership also counted when they divorced, because otherwise you could have strange results. If, for example, the couple bought a house during the civil partnership, then changed their relationship to a marriage, and then subsequently divorced, if we didn't make provision, there'd be a risk that that house wouldn't necessarily be counted as matrimonial property for the purposes of Scots divorce law, and that could produce some strange results. So the intention really is to ensure that, on that example, everything that the couple did during the civil partnership also counts towards their marriage.
Yeah, okay. And given the apparent breadth of this power, was there any consideration then given to using applying the affirmative procedure?
Yes, I mean, obviously the affirmative procedure does apply if we are modifying any enactment. So clearly, if there's any changes to primary legislation, the affirmative procedure would apply. And obviously, we considered the possibility of an affirmative procedure. We considered all the potential procedures when looking at this, but concluded that, on the whole, as it is mirrored in provisions in the bill elsewhere, and as it's a reasonably straightforward sort of process, we thought that negative procedure was appropriate, except where we're amending primary legislation. But I would accept, of course, that arguments could be made the other way as well.
Thank you very much. I'm wondering if I could just go back to the first area of questioning. I heard you say very clearly that the intention was that the effect of these two would be the same. I'm quite with that. What's still not clear to me is why you should need to have provisions that explain the effect of a marriage or a civil partnership in the first place, because that's surely a state relationship which doesn't need its effects modified.
Well, one example is the one I've just given, that if we just said the qualifying civil partnership is a marriage, then one question would arise about the matrimonial property regime, for example. Section 9.1 makes reference to that the civil partners are to be treated as having been married to each other since the date on which the qualifying civil partnership was registered, and that ensures that the matrimonial property regime covers the period when they're in the qualifying civil partnership. We'd want to do something similar in respect of civil partners who change under the administrative route under Section 8 to ensure that any property they acquired in the civil partnership would subsequently count if they should divorce their marriage later on.
So it'd be fair to say that the effects that you want to legislate on are the effects of the change from one state to another, rather than actually the state from which they came or the state to which they go, because surely the effect of being married is the effect of being married.
Yes, the effect of being married is indeed that you are married. It is what does that then mean in terms of being in the marriage? When does it date back from? Are there any other provisions we need to make specific reference to ensure that the couple get full rights and responsibilities?
So it's the effect of the transformation from one to another.
It's the effect of becoming
Thank you.
married.
I'm
yes.
grateful for that clarification. Thank you very much. I think that then takes us on to Margaret. Thank you.
Good morning. Could you there's three parts to this question. Could you explain what the legal implications of a renewed marriage ceremony or renewed civil partnership ceremony would be? What status will a renewed marriage or partnership have? And are these to be understood as new legal concepts?
Thank you. The legal status is that the couple would be regarded as married or in the civil partnership, but you wouldn't need to go through the marriage or civil partnership ceremony to achieve that status. The bill has already got provision in it saying that when a couple undergo gender recognition, their marriage or civil partnership continues. So the legal effect of Section 28 is it's simply allowing them to have a ceremony to reflect their new acquired genders. It's not meant to change the legal status of their marriage or civil partnership, and there wouldn't be any obligation on the couple to undergo a renewed marriage or civil partnership ceremony. It'll be one option open to them if they wish to take it up after they've acquired gender recognition. And to an extent, we are borrowing here a bit from provisions already in place in the Marriage Scotland Act, which I think it's Section 20 from memory, which allow a couple who've married overseas, but the marriage turns out to be of doubtful validity, to have a second marriage ceremony in Scotland. Now, this isn't quite the same, because what we're saying in this case is that the couple continue in their marriage, continue in their civil partnership, but we're borrowing the broad concept, the idea that they could, if they wanted to, have a second ceremony in Scotland simply to reflect their acquired genders. Their status is that they will simply continue to be married or in the civil partnership as they would be before they entered into the renewed marriage or civil partnership. So their status as such wouldn't actually change. What it would do is it's one way of enabling them to get a revised marriage or civil partnership certificate reflecting their new acquired gender, because obviously they married or entered the civil partnership in their previous genders, and this would allow them to have a marriage or civil partnership certificate reflecting their acquired genders. And one of the key things we're trying to do in this bill, more generally in respect of transgender people, is we're trying to avoid outing them inadvertently. And what we're trying to do with this provision and other provisions in the bill is trying to ensure that any certificates they have are as close as possible to other certificates held by married people or by people in civil partnerships, to avoid outing transgender people as trans.
Okay, is that, could I then take us on, John, please?
We're interested to know the power at Section 28(2)(h) to make provision about the effect of entering into a renewed marriage or partnership. And can you explain, perhaps you already have, I'm not entirely sure, to the committee the intention behind this power and what sort of provision will it be used to make?
And the intention was, if we needed to make any provision about the effect of having a renewed marriage or renewed civil partnership, that was the sort of area we were looking at. We have continued discussions with key stakeholders on any use of Section 28, and I think at the moment our thinking would probably be that we might not necessarily need to use H, because, as I said earlier, the effect of entering into a new marriage or renewed civil partnership means that they continue in their marriage or civil partnership. It may be that we possibly, in the regulations, if we should make any, might actually just need to say that, to put it beyond doubt, and just for the avoidance of doubt. But I wouldn't have thought that we would actually be needing to make any specific provision beyond that in terms of the effect of entering into the renewed civil marriage or the renewed civil partnership or renewed marriage, because in practice, as I said, the effect is they will simply continue in their current relationship.
Okay. Is it envisaged that the power at Section 28(2)(h) might have the effect of altering a person's legal status?
we would not be planning to alter their legal status. The intention is that once they've acquired their full gender recognition certificate from the gender recognition panel, they will then be legally recognised in their acquired gender, and they could then have a renewed marriage or renewed civil partnership. But we wouldn't be changing their legal status by any provision made under that power there.
Given the potential significance of this power, was any consideration given to applying the affirmative procedure at all times, and not just when modifying the primary legislation?
Yes, I mean, we did consider the possibility of affirmative for this. In general terms, we would say that this is mainly about the ceremony that people would need to go through to have the renewed marriage or civil partnership, and so when it's just about issues in relation to the ceremony that a couple have got to go through, then that would be a negative procedure traditionally. But again, I can understand that you might make a different point of view, the same point as I made to Mr Mackenzie.
Finally, I mean, was any consideration given to providing detail of or clarifying the status of renewed marriage or renewed partnerships on the face of the bill?
Not necessarily on the face of the bill. We tried to provide some explanatory material in the delegated powers memorandum, and in very broad terms, what we're doing here is similar to what we're doing elsewhere in the bill in relation to the changing of civil partnerships to a marriage. When civil partnerships change to a marriage, and there's two routes, there's an administrative route or there's a ceremony route. Now, in this case, the couple aren't changing; the couple are staying in their relationship. But it's a similar sort of concept in that again there'll be two routes for recognising their acquired gender. They could either have a renewed marriage or civil partnership ceremony to reflect their acquired gender, or there's provision in the bill elsewhere so that changes can be made to marriage and civil partnership certificates through the administrative route. So it's the same type of concept, really. So we're following the similar concept throughout the bill. Circumstances vary, but the concept is the same.
Pretty fundamental.
I would accept that any provision which had the effect of changing somebody's legal status would be a fundamental point, yes.
But, but since you argue it's not going to change the legal status, that's your justification for not putting it on the face of the bill, so to speak.
Yes, I mean, there's no intention here to change their legal status. There's obviously other provisions in the bill which allow people to change their civil partnerships to a marriage, and there's provisions in the bill in respect of gender recognition which go into some considerable detail about how the couple can acquire a full gender recognition certificate and stay in the marriage or stay in the civil partnership. Those are pretty fundamental principles in the bill, and gender recognition is certainly a major feature in the bill because gender recognition is very important for the number of people that it affects. So we've got quite a lot of detail elsewhere in the bill on those sorts of issues. So I'm not sure that we would necessarily accept that we needed more detail here. There's already quite a lot of detail about what the regulations can actually provide for. Thank you.
I'm just wondering if I could pursue point a little, because it's just possible, I think, to look at all the detail and all the transformations and all the options and perhaps draw the conclusion that because there are different ways of doing things, that actually there are different states, if I can come back. Actually, if there are only two, arguably three, like being single, then why don't we just say so and actually be clear on the face of the bill that this, or this, but it doesn't matter how you get between one and the other, nonetheless they are the same. I just wonder whether it might be worth saying.
I mean, that would have been an alternative approach, but it depends obviously how best to do it, because as I said to Mr Scott, generally for these types of changes we provided two routes to do it. We provided the administrative route, or we provided the ceremony route, and provision is then made within the sections to reflect that. But in terms of the high level policy, then yes, I'm happy to say that we wouldn't have different types of civil partners or different types of marriages depending on what sort of route they've gone through. The message is that once you're married, you're married, and in that respect it's very similar, for example, to what happens now with marriage ceremonies. If you had a religious ceremony or a civil ceremony, then once you're in the marriage, then you are married, really. It doesn't matter how you got there, and it will be the same with this.
Right, I think our last set of questions comes from Stuart Stevenson.
Thank you, Convener. And my questions relate to Schedule 2 changes to the Gender Recognition Act, and in particular to Section 6, where we're inserting 5D. And in my first question on adding 5D to the Gender Recognition Act is simply what circumstances are covered by the phrase additional circumstances. Now, it may not be possible to give a definitive and complete list, but some examples might be of modest help.
Yes, Mr. Stevenson. We are struggling with this at the moment. Currently, the bill has got a couple of ways in which a civil partner can obtain gender recognition and change that relationship to a marriage. And civil partners who are undergoing gender recognition do need to change their relationship to a marriage because we're not introducing opposite-sex civil partnership. There's one exception to that, which is where both civil partners are changing gender at the same time. Then they can stay in their relationship because they are staying in a same-sex relationship.
So can I just immediately pick, they can stay in their civil partnership, yes, as distinct from relationship?
Yes, yes, indeed. That is quite
the
right.
The word relationship's an informal word you
yes.
were accidentally using.
No, that is quite right. They could stay in a relationship even if they didn't stay in a civil partnership. That is entirely right. What we are suggesting here with this power is whether there are any simpler ways to allow a civil partner to obtain gender recognition and change to a marriage at the same time. We had one option in the consultation paper, which was that a civil partner would apply to the gender recognition panel for gender recognition, would obtain an interim gender recognition certificate in the normal way, and would then use that interim gender recognition certificate to get married, and thus have the change to the marriage status there and then, and would use the interim gender recognition certificate showing their acquired gender rather than showing their previous gender. Now, this was in the consultation paper, and there are some arguments against that, and the most pressing argument against it is, does it give an additional status to interim gender recognition certificates, which we wouldn't want to give them? But that's one potential use of the power, possibly. Another variation on that is to allow the couple to get married in their acquired gender after they've received the full gender recognition certificate, but the full gender recognition certificate wouldn't actually be formally signed off until they got married. There's an argument against that as well, because it raises questions about the nature of the full gender recognition certificate. There are other similar options like that, which we're currently going through, but the aim of the power really is to see if we can devise a procedure which would enable somebody in a civil partnership to obtain gender recognition and to change their marriage in fewer steps rather than the number of steps they have to do at the moment, given we're not introducing opposite-sex civil partnership.
Well, that leads me neatly to, given that the complications which we're struggling with here seem to derive from the impermissibility under this legislation for people who become of opposite gender to remain civil partners, was there a drafting or legal difficulty that inhibited the provision within this bill or elsewhere of civil partnerships of people of opposite genders, or was that a policy decision?
The policy is obviously that this bill is not introducing opposite-sex civil partnerships. The Cabinet Secretary has announced a review of civil partnerships, which will clearly look at that option and look at other options in relation to civil partnerships. Given that is the general policy in relation to opposite-sex civil partnerships, we would not want a situation where a person in a civil partnership could somehow claim to be in an opposite-sex civil partnership. So certainly provisions have been reflect the fact that there is at the moment no intention of introducing opposite-sex civil partnerships.
Just for clarity, Mr. Stockwell, you are not suggesting as an official that you would be unable to provide in a reasonable way for legislation that allowed civil partners to be of opposite genders. In other words, it is at this stage purely a policy issue rather than an issue that lies with practical difficulties.
In my experience, Mr Stevenson, parliamentary draftsmen can do anything. So if policy was that we wanted to introduce opposite-sex civil partnerships, I'm sure parliamentary draftsmen could produce me provisions within the usual timescale. It is a matter of policy that we're not introducing opposite-sex civil partnerships rather than a matter of drafting or law.
Right, that's helpful. Joe.
Since my question was around that, and it is a matter of policy, I'm not sure that we can stray into that question, although earlier a convener did say that he wouldn't be too sore on those of us who did. So, by not introducing opposite-sex civil partnerships, are you in some way disadvantaging those of opposite sex who wish to be
Well, that is quite clearly a policy decision,
in a civil partnership?
which, to be fair to Mr Stockwell, I don't think he's actually required to answer in the context of this committee. He might well find in another committee he's required to answer that question, but I think, to be fair, that's not for us. My point was that we did need to understand the policy in order to understand the detail of the questions which we do have before us.
And the simple answer to the question, obviously, is the Cabinet Secretary has announced a review of civil partnerships, which obviously will look at civil partnerships in the round, whether that's opposite-sex civil partnerships or stopping new entrants into civil partnerships or any other variations in relation to civil partnerships. That is a simple answer to the question.
Just on that subject, has the Cabinet Secretary indicated a timetable? And in particular, is there an expectation that review of civil partnerships could be completed prior to the deadline for laying stage 3 amendments for this bill?
No, it won't be completed by then, Mr Stevenson.
So we already know it will not be?
It will not be. That's not the intention. We have begun the process by the Cabinet Secretary has written to other party leaders, or other party spokesperson rather, to ask their views on the terms of remit. We intend to publish the terms of remit fairly soon, but the bulk of the work over the next 6 months is obviously going to be concentrating on this bill, and then the review will start in earnest once the bill is through.
Do colleagues have any other questions? No, I think that's it. Thank you very much indeed for your time.
Mr. Don.
Appreciate that. We'll suspend just for a couple of minutes in order to get you through the door and enable people to draw breath. Very much indeed. That brings us on to agenda item 4, which is instruments subject to affirmative procedure. No points have been raised by our legal advisors on the National Health Service Cross-Border Healthcare Scotland Regulations 2013 draft. Is the committee content with that instrument, please? Agenda item 5, instruments subject to negative procedure. No points have been raised by our legal advisors on the Civil Contingencies Act 2004, Contingency Planning Scotland Amendment Regulations 2013, SSI 2013-247, nor on the legal aid and advice and assistance, photocopying fees and welfare reform, miscellaneous amendments Scotland Regulations 2013, SSI 2013-250. Is the committee content with these, please?
Content.
We are. So I want to change next. Agenda item 6, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisors on the Act of Sederant Registration Appeal Court 2013, SSI 2013-236, nor on the Act of Sederant Summary Applications, Statutory Applications and Appeals, etc. Rules Amendment, Policing and Crime Act 2009, 2013, SSI 2013-241, nor on the Aquaculture and Fisheries Scotland Act 2013 Commencement and Transitional Provisions Order 2013 SSI 2013-249. Is the committee content with these instruments? Please. Thank you. Agenda item 7. The purpose of this item is for the committee to consider the delegated powers in the Children and Young People Scotland Bill at stage 1. Members have seen the briefing paper outlining suggested questions. Committee is invited to consider its approach and agree the issues it wishes to raise in written correspondence with the Scottish Government. The letter setting out these issues and the questions they precipitate will be published on the committee's website later on today. Firstly, with regard to the powers under section 13(1)(b)(2) and 17(6), which relate to children's services plans and planning, the committee may wish to seek clarity on the effects of the powers, the reasons for taking them, and the procedure attached to the power at section 13(1)(b). Do members have any further comments? Is the committee content with those? Thank you. Secondly, the committee may wish to seek clarity on the purpose and the power under section 32, which relates to the interpretation of part 4. The committee may wish to seek further information from the Scottish Government on the powers under sections 32(2) and 37(5), which relate to child's plans. In particular, the committee may wish to seek further information in relation to the accuracy of and sufficiency of reasons provided in the Delegated Powers Memorandum and clarity of the power under section 32(2), and on the choice of procedure as regards both powers. The committee have any comments on those? Is the committee content to raise those issues with the Scottish Government? Content. Yes. Thank you. Committee may wish to seek further explanation of the choice of procedure applied to the powers under sections 43(2)(c)(2), which concerns the provision of early learning and childcare, section 61(3), which relates to eligibility for counselling services for parents and others, and section 64(4), which pertains to assistance in relation to kinship care orders. Members have any comments on those?
Before you move on,
yeah,
I had an issue in relation to page 15, the previous page, at paragraph 83, and it's around child's plan and the management of a children's plan. And my concern is around the breadth of the power and the use of the negative procedure. So I would be grateful if committee could raise that with the government for an explanation as to why they're using that specific power, given the breadth and scope of what they're talking about.
Thank you. I think I've just covered that because I think you're referring to 37(5).
I may well be.
Okay, section 37.
Yeah.
Yep. Okay.
Yeah, 37.
Which
yeah.
I think I just suggested we should address.
Right. Sorry.
That's okay. That's okay. Thank you.
Just want to make sure it's there.
No, that's fine. Okay. Sorry, where have I now got? Okay. Right. With regard to provisions on Scotland's adoption register contained in section 68 of the bill, the committee may wish to seek further explanation of the reasons for taking the powers, the scope of the powers, and on their intended effects. The committee may also wish to seek an explanation for the delegation of functions in relation to the register by arrangements. Members have any comments? Are we happy to raise those issues with the Scottish Government? We are. Thank you. Committee may wish to seek clarity on the choice of procedure and the overlap between powers contained in sections 78(b), which confers powers on the Scottish ministers to make separate ancillary provision, and section 79(2), which includes the power to make ancillary provision alongside provision for commencement. Are members content with that? Do we have any comments? Yeah. We are. Thank you. Finally, the committee may wish to ask the Scottish Government whether it considers it appropriate that the guidance and directions which are provided for in sections 28(1), 29(1), 39(1), 40(1) and 74(3) should be published. Do members have any comments? General agreement. Thank you very much. Based on what has been agreed today, the committee will write to the Scottish Government setting out these questions, as per our brief, of course. As previously mentioned, the letter will be published on the committee's website later today, and the committee will consider a draft report on the basis of the responses at a later date. Thank you. That completes agenda item 7, so we now move into private.